while you're dealing with the act of God also. You're saying the plaintiff was aware of it. If the plaintiff was aware of it and briefed about it, that means you had a greater knowledge about it because it was something which was certain, bound to happen. The argument was it was always there and it was bound to happen, and plaintiff was made known about it.
Your Lordship, the different accept the fact that the bacterial infection was foreseeable, as as the bacterial infection is common in that island. But we cannot accept the fact that the defendant would foresee that Laura was weak and she could acquire the disease and the severity of the disease that would take place in Laura, Your Lordship. The bacterial infection had converted, had caused acute laryngitis, which is of severity in nature. But that took place because of her weak immune system, which we cannot foresee, and Laura did not inform us in prior, Lordship. That is
So,
the foreseeability part we contend with.
in spite of foreseeing that there could be an infection, you have not done anything to prevent it from your side.
Your Lordship, we did not leave Laura strangled on an island, but we did give her an accommodation facility as to general basic welfare. Legally speaking, we are just.
It is not about accommodation, it is about the infection. Have you taken any measures to prevent and look into the safety and health of the participants there?
Your Lordship, legally, as my co-counsel explained, we do not owe a duty of care exceptional to fumigate the house, but as a reasonable man, we can only take a reasonable extension of care, Your Lordship. The fumigation was out of exceptionary to foresee prior reasonable. Your Lordship, in the case of Hall's Brookland, it was stated the reasonable man definition was that any man who's on the road and he is not perfect, his foreseeability should not be perfect, but also as an average man, as an average prudent man, except compared to all the measures. But they cannot foresee the event in between as to take the extraordinary measure. We cannot stop all the.
You yourself have admitted, isn't it, that you could foresee. You have foreseen.
We are foreseen the bacterial infection, Lordship, but as legally we are not bound to take a precautionary measure as to fumigating the house, as we cannot stop the possibility of every event affecting Laura, Lordship. As a prudent man, we cannot stop all the possibilities, Your Lordship, because bacterial infection causation itself is not near in this case, as it could pass through spread or infection. Fumigation is not the sole cause in this case, as to take a perfect prevention to stop the infection, Your Lordship.
Continue, please.
I would like to state London is Discovery Communications.
I have put it on the. This is operational as well. This is the same thing. This just leads to our channel. So they'll watch it, and this is the DR. That was it. Both of them are.
Your Lordship, in this case, when the defendant for an intentional harm pleaded the defense of exceptory clause, it was stated that the exceptory clause immunizes only for an negligence, Your Lordship. That is, in this case, when he pleaded a precedent case of Dr. Clapper, the court did not rule that, and it said only for negligence case it is applicable, stating that relying on that judgment, that exceptory clause carve out the exception of negligence. We would like to say that Laura cannot claim, as she knew the risk, as before I stated in the facts of the case, she knew the risk very well. So she cannot claim the defendant as for negligence.
Let's send to the family members.
If you are watching this satisfied, may I move on to the
Please go ahead. Please go ahead.
much obliged. Your Lordship, the issue 3 is whether plea of this nature is justifiable. Your Lordship, as I stated in my previous bacterial infection foreseeability, the bacterial infection foreseeability was not, severity was not foreseeable, and there was an act of God as to bacterial infection converting to an acute laryngitis and hold all the consequences in future development. As in the case of Ryland with Fletcher, it was stated that inevitable accident arising out of natural resources constitute an act of God. Your Lordship, in this case, it was purely of an inevitable accident, as they cannot avoid the bacterial infection converting to an acute laryngitis and causing all this inflammation. So, and the main possible event is that of a bacteria, which is a natural resources, and hence they cannot contend that it is not an act of God. Your Lordship. Your Lordship, in this case, it is stated that it is the acute laryngitis is predominantly caused by virus and not by a bacterial infection. In very rare circumstances, only bacterial infection can cause acute laryngitis. So, Your Lordship, in this case, when a bacterial infection causing an acute laryngitis of rare circumstances is totally unforeseeable by a defendant to take precautionary measures, Your Lordship. And we do not have a duty bound as to fumigate purpose. Your Lordship, the two conditions of the natural resources of the act of God is that work of natural resources, which is of the bacteria.
If I may intervene, you are saying that if you're not duty bound, means your whole argument will go to show that you are negligent. Having known, having briefed them, and having done, it's not an act of God, which happened all of a sudden. It's a pre-existing state of affairs in a backward island. If it's a pre-existing state of affairs, that is bacteria being a common problem and which may result in harming the health, you cannot say it's an act of God. So therefore, and you are saying that having known, having briefed the plaintiff, you have not done it, it only goes to negligence. So therefore, when you put across a point, don't go to an extreme point where you may get hit by your own argument.
Your Lordship, actually, I would like to submit that negligence happens only when the over duty of care in the first place. But whereas, as my co-counsel explained, we do not over duty of care to fumigate medicines because it is of special obligation. Special obligation occurs when Laura explained to us, but she did not explain to us. Then how could we foresee that Laura was weak enough to get the bacterial infection and do a precautionary measure? She did not come and explain about her. She did not take a step further to explain about her weak immune system. So duty of care cannot be constituted here. That's because the duty of care cannot be constituted.
Just one last question, just to answer, because you got 2 more minutes. Your basis that you are not entitled to fumigate, and it is a special thing itself, may be flawed, because giving a clean environment as well as a clean room was a basic requirement. It should be like good hygiene, food, water, and place to shelter was a very basic requirement which thing you could have given. If not a luxury, but a disease-free or a clean room. So therefore, to say that that was not requirement of special, it is of special requirement may not be correct. How do you answer that?
Your Lordship, fumigation is different from that of a clean facilities. Whereas we provided Laura the accommodation facilities, the basic care which comes under the common duty of care. The facts clearly states that she was far impressed. Whereas which we cannot give her a luxury effort, but we actually gave her the best what we could give in a paradise island. So fumigation is totally different.
What you're trying to say is the room was clean, everything was taken care. Fumigation is over and above giving a clean room. That is what you're trying to say.
Indeed, Your Lordship. Indeed, Your Lordship. And the facts are sent as to the rooms not being given, Your Lordship. Your Lordship is satisfied?
Please.
I would like to state that the act of God constitutes the two main resources, that is the natural resource, and second is that human intervention has to stop it from converting to an acute laryngitis, which led to the unforeseeable damages. The
No, I actually have.
I would like to, really sorry for it. I would like to state that the act of God constitutes the two main resources, that is, the act of natural resources and the human intervention as to stop it from converting to acute laryngitis, which is of an inevitable accident caused by a natural resource. Your Lordship, if you permit, may I please move on to the prayer?
Yeah, please.
Uh,
Please go ahead.
Therefore, in the lights of the issues raised, arguments advanced, and authorities cited, it's most humbly submitted before this honorable court to kindly dismiss the suit by the plaintiff and also pass any order or orders that the court may deem fit. For this act of kindness, the counsel shall be duty bound for it. If it is of no inconvenience to the court, the counsel like to rest the case.
Judges, we can start the rebuttals by the
Yeah,
plaintiff.
please.
Thank you, Your Lordship. Here I would like to.
So before the rebuttal, what I'll take one or two questions. You just answer those. You are aware of the fact, just in your rebuttal, just to answer this. You are aware that you are going to a remote place.
Yes, Your Lordship. You asking me questions, Your Lordship, or
I'm
defending?
stating you a few facts which are on record. You are aware that you are going to a place which was a backward place.
Indeed,
A
Your
remote
Lordship.
place. So not a backward place, a remote place.
Indeed, Your Lordship.
And in a remote place which is in they're bound to have diseases or whatever, they're not properly humanly habitated. Therefore, usually when we travel abroad, we take medical insurance, we take medicines along with us, isn't it?
Indeed, Your Lordship.
And the next thing what we do is, why didn't you take those things so that you can reduce the thing? That's the natural things which may do, which you're bound to do. So second and most important is, why is there a delay in reporting to them? And the last point, point is, how do she's trying to put it, saying that they're taken care, but not fumigation was not necessary, to put it in other words.
Okay, indeed, Your Lordship. Firstly, to consider with respect to the medical precautions that Laura had to take, Your Lordship, it was obviously not reasonably foreseeable that she would acquire the disease. Contraction of any infection or coming in contact with any microorganism was not reasonably foreseeable, Your Lordship. She was completely dependent on the defendants for the arrangements on the island. So that completes the first question, Your Lordship. Second was that, in fact, that she was traveling to remote island. She knew that, but then she relied upon the defendant's arrangements, Your Lordship. And fumigation of rooms was very much required, as the defendants themselves have confessed that it would have reduced or minimized the risk of contracting the infection, Your Lordship. So it would have definitely reduced the probability of acquiring the disease. And with regard to informing the defendants about the discomfort, she actually felt the physical discomfort with respect to accommodation, Your Lordship. Here, the onset of symptoms regarding to acute laryngitis is immediate or within a span of 1 week, Your Lordship. It's usually immediate. So here, this was done on this can be relied upon the medical research that we have done. So the symptoms of the acute laryngitis was immediate as in when she acquired the disease, Your Lordship. So she didn't delay on informing the defendants when she saw the symptoms. The facts are also silent on that, but with relevance to the medical research, we can deduct that the onset of symptoms was immediate due to the acquiring of bacterial acute laryngitis, Your Lordship. So I hope this satisfies your. With going with the rebuttals, Your Lordship. Firstly, the counsel for defendants said that they were negligent, so the entire arguments goes futile, your lordship. And secondly, they say that the bacterial infection contraction was reasonably foreseeable. Again, they failed to explain that it was not reasonably foreseeable, so it was reasonably foreseeable by them, which holds them negligent as they have failed to perform their duty of care by not fumigating the rooms, your lordship. Secondly, they said that acute laryngitis is commonly caused by viruses and not bacteria, but diphtheria is the only bacteria that causes acute laryngitis. No, your lordship. There are many other bacteria that cause, there are spherical and other cocci bacteria forms which cause acute laryngitis, your lordship. My researcher will be sharing sharing that medical report, medical research, your lordship. So with respect to these, and also para 30th of the moot proposition states that the precautions, she should have taken some precautions with respect to the contracting of infection. What are the precautions she could take? What were the precautions she could take when she was not reasonably foresee, when she could not reasonably foresee her contracting the infection, your lordship? Then with respect to one more, your lordship, her silence with respect to the facilities of the accommodation is different from her reasonably foreseeing her contracting the disease, your lordship. There is a difference between the physical discomfort that she faced in the accommodation, and and that she could not foresee her contracting the infection. This is also one of the point I would like to highlight, your lordship. And with reference to this says that the fumigation of rooms does not form any extraordinary precautions as told by the counsel for defendant. I would like to say that even in the present scenario where sanitization of different places are in different places are being done in order to avoid the coronavirus attack, your lordship. Similarly, that forms the base sanitization. The present scenario forms the basic facility. So similarly, when bacteria is commonly found on the island, fumigation forms the basic facilities, no extraordinary precautions, your lordship. So here also, that was also one of the points that I would like to highlight. And since the symptoms of immediately seen on the contraction of the bacteria, that would say that she did not she did not delay in complaining to the defendants. And also one more point that I would like to highlight is that your lordship, if it, 1 minute, your lordship. And that's it, your lordship. If the counsel
Thank
is
you.
thank you, your lordship. Much obliged. It was on honor arguing before the bench.
It was a pleasure hearing you.
Your Lordship, if may permit, may I please move on to the SAR rebuttals?
Yeah, proceed, please.
Much obliged. Your Lordship, as the question, meaning a rebuttal was raised regarding the contributory negligence, I would like to establish that the main part of the contributory negligence is that if there are the part of if there is a possibility to reduce it by the plaintiff cannot claim compensation. Even if there is a minimum possibility, if it would have reduced the damages drastically, then clearly the negligence doesn't fall on the defendant. That's regarding the contributory negligence. Moving on to the argument regarding the diphtheria, we would like to, as we already showed the vaccines, we have also provided facts regarding the vaccines to other bacteria that might also affect it, which clearly states that there are bacteria, meaning there are vaccines to other bacteria as well, and there are medications to other bacteria as well. All these vaccines and medications are available to a prudent man. Even while before coming, Laura could have made sure that she's much prepared to face these consequences, because the nature of the show itself is a back to nature show, which clearly can be said that she is duty bound to make sure she can face these consequences. Even if it is not the defendant's negligence, she should be well prepared to make sure she's facing it in the right way, Your Lordship. Moving on to the silence that the plaintiff had told, Your Lordship, silence to the accommodation clearly she's accepting what we have provided, Your Lordship. And moreover, it is clearly given in the fact that she has developed a bacterial infection. the council had council for the plaintiff stated that the acute laryngitis takes a period of 1 week to develop. But here, Your Lordship, initially the bacterial infection was the one which was developed, and it had many symptoms to be developed in a course of time. Clearly, we are not dealing with acute laryngitis, but a bacterial infection which affected Laura takes a due course of time, and it is clearly mentioned that it was developed in due course of time. Yet she remained silent, and she informed only after all these symptoms got severe. That is why it led to the possibility of laryngitis. That is why we are not obliged to pay damages for the laryngitis, Your Lordship. Going on to the regarding people who migrate in the cities, like when there is a corona situation, we would like to submit that Your Lordship, here there is no occupier invitee relationship, or there's no relationship. The government is bound to do these things to safeguard their citizens, Your Lordship. But in the present case, Laura only bound to participate in the show for a time being, and Excel Telefilms is only bound to take reasonable care for the time being. Lordship, in this case, one cannot compare it with a pandemic situation, because it is a temporary bacterial infection which clearly was not able to be foreseeable, thus cannot be guarded against it. The council would like to rest the argument, Your Lordship.
Thank you.
The teams can now leave the meeting. Thank you.
Thank you.
Thank you.
Thank you.
This is one. Yeah, you talk to Manish.
Why it's done?
Now, judges will discuss this also. We cannot see.